parenting orders are put in place by the court, the Family Law Act regards the best interests of the child as the most important consideration. So tell me, Diane, how are the child's best interests represented in court?
Well, as is always the case, the paramount principle for the court is what is best for the children. And the court looks at a number of factors when considering what is best. Now, what is best is one of those discretionary issues and factors or concepts. And the phrase best interest is a legal one. And there are a list of things the court will look at or look to when considering or determining if something is best for that child.
So can a lawyer act for a child then?
Well, technically the lawyer doesn't represent the child. The lawyer represents the interests, the best interests of the child. So a lawyer can be appointed by the court in certain parenting matters. In quite serious cases, the court will probably appoint what we call an independent children's lawyer. And they will present information to the court about the children's welfare and views. Now, this lawyer won't sit down with the child and take instructions like you would ordinarily do with a client. The lawyer will undertake their own investigations because they've been appointed by the court to provide information to the court on what arrangements that person considers based on the information they have to be best for the child. They're like an honest broker, if I can put it that way.
Yeah, because there are some children in situations where both parents aren't very good for them, I'm guessing, and that's where this sort of lawyer will come into play.
What the court will look at is the circumstances of the cases. If there is potential for there to be there's been allegations made that are quite serious allegations, the court may appoint an independent child lawyer to assist the court in relation to obtaining information about the parents, obtaining information about the child in order to present to the court other information that the parties may not necessarily want put before the court, so that the court can determine what's best for the children.
So how can a child be heard during this situation? Is it just by a lawyer? Does the child need to go to the court,
So in difficult cases where the court may appoint an independent child lawyer, that independent child lawyer will probably appoint a person to prepare a written report about the child. Now, this is commonly referred to as a family report, and if anyone who's watching this video goes in and puts family report into Google, it will come up with fact sheets on what a family report is. This report is prepared by a consultant who's usually a social worker or a child psychologist or psychiatrist, depending on the case, and they obtain information by interviewing the parents, the child or children if it's appropriate, because as you can appreciate, they're probably not going to interview a 1 or 2 year old, but they'll probably interview or speak to a 12 or 13-year-old child. So for older children, the written report will inform the court of that child's views. And that is one of the factors that the court has to consider when looking at what's best for a child. Again, what's really important is just because a child has a view that they may want to live with a certain parent does not mean that that will mean that the court will make an order consistent with that view, because that view may not be on the whole what's best for the child in terms of an arrangement for them. So a child's view is one of many considerations, but that is how a child's view will be put across to the court by way of usually these reports.
So there you have it. The Family Law Act focuses on the rights of the children and the responsibilities of both parents, ensuring children are safe and have a meaningful relationship with both of their parents. So if you have any further questions, definitely get in touch with the experts at Ruhl Family Law Centre today. They'd be happy to help you.